Hi, this is Austin, and I'll be talking about the Miranda versus Arizona court case, which is representative of the Fifth and Sixth Amendment in action. Under the Fifth and Sixth Amendments, you're guaranteed 7 rights. Nobody can be held liable for a capital crime unless indicted by a grand jury. You can't be tried twice for the same crime. You can't testify against yourself. Private property can't be taken away without being compensated. Everyone is guaranteed the right to a speedy trial, a right to be confronted by witnesses testifying against them, and the right to a witness testifying in their favor. Under the Miranda rights, if you're arrested, you are guaranteed the right to remain silent. You have to have the right to remain silent. Anything you can and say will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. And with these rights in mind, do you wish to speak to the police officer? So it's a reminder of your rights under the Fifth and Sixth Amendment. Chief Justice Earl Warren, in his certiorari to the Supreme Court of Arizona, viewed the case in relation to the restraints society must observe consistent with the federal Constitution and prosecuting individuals for crime. In the Miranda case, it was found that in none of these cases was the defendant given a full and effective warning of his rights at the outset of the interrogation process. At the time, the manual for police interrogation was criminal interrogations and confessions, which advises the police officer to deprive the suspect of all psychological advantage in order to gain a confession. The police officer is also told to assume the suspect is guilty. The manual goes as far to advise trickery in order to gain a confession from the suspect. The evidence was weighed into the court decision that found the police did not give a reminder of the rights at the beginning of the interrogation process. There are 4 cases related to police interrogation cases where the procedure itself was in question that are tested under the Miranda versus Arizona court case. Miranda versus Arizona, Miranda versus New York, Westover versus United States, and California versus Stewart. Whereas in Miranda versus Arizona, the defendant was taken to a special room for interrogation, and Venera, the defendant orally admitted to the crime, then signed a statement after being questioned by a district attorney later that day. In Westover, the defendant was handed over to the FBI after being extensively interrogated at night and the following morning. After 2 hours with the FBI, the defendant had made signed statements. And in California, the defendant was held 5 days by the police where he was interrogated 9 times before he signed a statement. The court found that in these cases, except for California, that the defendant's confessions were involuntary and non-traditional terms. All these cases, except for California, were reversed, which was affirmed. The problem with California being that the court could not find any warnings that the defendant in the case was deprived of their rights. The case concerns Ernesto Miranda, who is charged with rape and kidnapping. An 18-year-old girl was kidnapped and raped on November 3, 1963 near Phoenix, Arizona. Miranda was sentenced to 20 to 30 years on each count served concurrently. He was arrested at his house and then brought in to be questioned. It took 2 hours of interrogation to obtain a confession from Miranda. The confession was admitted as evidence to the trial despite the objections of the defense attorney. Miranda had not been advised of his right to have an attorney present during the interrogation. He was found guilty, and on appeal to the Supreme Court of Arizona, he was found guilty, and it was found that his constitutional rights had not been violated. On June 3, 1966, it was decided that a reverse in the decision in the case was to be made, given that Miranda had not been informed of his right to have an attorney present at the interrogation. The court found that without a warning of his right to have counsel at the interrogation, the evidence had become inadmissible. Prior to the 1966 ruling of Miranda, there was a similar case in Escobedo versus Illinois. In Escobedo, there were similarities to the Miranda case. The police took in a murder suspect and interrogated him without acknowledging his request for a lawyer. The Supreme Court ultimately reversed his conviction given that he was denied his request for a lawyer at the time of interrogation. This set a precedent for the Miranda decision given that it was decided 2 years prior to the Miranda decision. In the Escobedo case, it is further stated that the counsel is present when statements are taken from an individual during interrogation obviously enhances the integrity of the fact-finding processes in court. So for the Supreme Court, the process of police interrogation itself was in question given that there were multiple cases where an individual was either denied or not informed of the right to counsel at the time of interrogation. So again, there was a need to balance society's need for police investigations with the privilege of rights. Much of the Miranda decision concerns the idea of being protected against self-incrimination. There is, for instance, the case of Brand versus United States, where it was argued that confessions are deemed invalid because they were not voluntary. Brand concluded that in order to render a statement admissible, the proof must be adequate to establish that the particular communications contained in a statement were voluntarily made. There is a similar decision in Wan versus United States, where it found that a confession made by compulsion must be excluded, whatever may have been the character of the compulsion. Similarly, in Britain, there was the Summary Jurisdiction Act of 1848, which banned judges from questioning suspects about crimes of which they may have been a part. So, what is surprising is that there's an overwhelming amount of cases that have upheld Miranda versus Arizona over the years, which is surprising given the objection that we're going to get to. There's Harris versus New York, where Harris is arrested for selling heroin to an undercover police officer twice. The court decided in the police officer's favor, arguing Harris's Miranda rights had not been violated. There's Arizona versus Robertson. Robertson was arrested at the scene of a burglary. He incriminated himself during his interrogation. The court held that his Fifth Amendment rights had been violated. There's Illinois versus Perkins. Perkins admitted to the crime to an undercover police officer posing as an inmate. The court ruled his Miranda rights had not been violated. There's Dickerson versus United States. A suspect was indicted for robbery as well as two other related charges. It upheld the constitutionality of the Miranda rights requirement. There's Missouri versus Seibert. Patrice Seibert was convicted for the second-degree murder of 17-year-old Donald Rector. The police initially withheld her Miranda rights during interrogation. The Supreme Court sided with Seibert and the conviction was overturned. And in 2011, there was Bobby versus Dixon. Dixon was a suspect in the murder of Kirsten Wilkerson. Police questioned him and read him his Miranda rights. He was questioned a second time without his Miranda rights being read. The court held that not reading him his Miranda rights at the second interrogation was unconstitutional. And then there's the case of Vega versus Seiko, which is where the case that throws out the Miranda rights requirement. Miranda rights had become an issue not just about constitutional rights, but also of compensation for having your rights violated. Terence Seiko was an employee at a hospital. He was accused of sexually assaulting a patient. Deputy Carlos Vega interrogated Seiko over this incident. Vega did not read Seiko's Miranda rights. Seiko was arrested and later found guilty. He sued, alleging his Fifth Amendment rights had been violated. The court ruled that if a Miranda violation were tantamount to a violation of the Fifth Amendment, our answer would of course be different. And again, this is surprising because the Miranda rights requirement, it's a popular police requirement, and it had its popularity, and it was pretty much upheld for about 60 years. It was the standard for beginning a police interrogation. You know, they came out at the time of civil rights, so this was the turbulent 1960s, so they were they're from that era, where people were beginning to get, realize that they had all these rights under the Constitution. They had become a tool used against police officers in questioning their interrogation procedures, and they had made police interrogation work burdensome. It's not necessarily a bad thing that Miranda rights readings have been revoked, but it's surprising given its popularity and that it's for 60 years it's pretty much been upheld. I mean, there was the court case in 2000, Dickerson versus United States, where it was pretty much which upheld the constitutionality of the Miranda rights requirement.